I'm Tom Keeling of the FreemanFirm, and we represent over 100 landowners in this litigation.
Norm Matteoni, representing Property Reserve, Inc., owning 3,500 acres.
Well, what this is about is about 5 years ago, the state of California, in order to advance its twin tunnel scheme, decided it needed access to hundreds and hundreds of parcels of property in the Delta, totaling tens of thousands of acres. Rather than condemning the easements, that is, acquiring easements for all these many activities, many of them very physically invasive, such as drillings, such as laying animal traps, day and night entries, and so on, in order to get these rights and interests in the property, the state decided that it didn't want to afford landowners all of the protections and safeguards that come with the eminent domain law. Instead, they attempted to get these rights and interests under something we call the entry statute, which is a summary proceeding and does not include all of those safeguards.
Well, I would only add that we're relying primarily on a decision of the California Supreme Court that dates back to 1923 that involves some of the same issues we have in this case in terms of the extensive borings the state was attempting to achieve through the entry statute. And the court said that the entry statute is only for innocuous or superficial entries, not for any extended period of time, not for detailed occupancy of the land. So that's the thrust of what we were arguing today. The Jacobson case was decided in 1923. Its formal name is Jacobson versus the Superior Court, which, similar to this case, involved a writ where the trial court had given a right of entry for what at the time was a potential reservoir, and it gave a right of entry for various borings on the property that could go to 150 feet in depth, extend over a period of time. And the court said the entry statute of California is limited to minor intrusions on the land, what it called innocuous or superficial. Thus, what we were arguing today is that if you apply Jacobson to the entries the state sought for the investigations in this case, that they were very extensive in terms of environmental review, going through the property for various species investigations, for example, and we're doing borings on the property, taking soil samples at great depths, as well as what they call cone penetration tests, and then leaving holes that they would fill with bentonite, storing materials for a period of time on the land. So that's how Jacobson applied, as we saw it, to the case at hand.
There seemed to be one other case involved too, the Arkansas they mentioned.
The Arkansas game and fish case, which is a recent U.S. Supreme Court decision, discussed temporary takings in a very narrow context. It had to do with flooding and whether government-induced flooding can be the basis for a certain type of action. We don't think it applies at all, but in the discussion of temporary takings, the Arkansas game and fish case named various criteria for temporary takings. And it's our position that if you look at those criteria, for example, whether the taking was intentional, and certainly it was in our case, it's our contention that even if you apply Arkansas game and fish, it applies here. It supports our position.
Okay, now I noticed I came in shortly after it started, and the judge seemed to be pretty tough on you guys. I mean, it seemed to me like it's kind of going the wrong direction until the state's attorney got up there, and he was equally as hard on them. So can you kind of comment on the judge's questions, as you recall, and how you felt it was going at the time?
Well,
Go ahead.
I know better than to infer too much from comments by justices during oral argument at the Court of Appeal. They have had this thoroughly briefed internally. They have all reviewed the records and the briefs thoroughly. And they have often reasons for asking the questions the way they do and the questions they do that we are never going to understand even long after the decision comes out. I didn't hear any questions there today that did not indicate deeply engaged justices doing a good job.
One additional thought I would add, although the questions were indeed hard as the argument started, was trying to look at it favorably. The questions were set up through me, through Tom, since we started the argument, for what the justices wanted to finish with when it had the opportunity to ask similar questions of the state. So again, hard to interpret why certain questions are asked, but the harshness of the questions were, in my mind, equal, and sometimes I thought, as the argument proceeded, harder on the state.
I agree that they were hard questions, difficult questions, advanced to both sides, but they were no more difficult than the inherent complexity of the issues raised by the case. So they did not surprise me. The difficulty of these questions did not surprise me.